Hello. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores,
Present.
Senator Orenshaw, Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
And I am here. Please mark those members present who are not here yet, present when they arrive. If any of them fail to make it, you can mark them absent excused because, of course, it is that time of year. They're off presenting in other committees or sitting on other committees or doing other important legislative business. So we will jump right in. We have 2 bill presentations today. Unless somebody gives me a good reason in the next 27 seconds not to hear them in order, that's what I will do. And you don't want them in order? You want them out of order? Okay then, we will start with AB 489. And I am opening the hearing now on AB 489.
Good afternoon, Chair Scheibel and members of the committee. My name is Erica Roth, and I'm proud to represent Assembly District 24 in Washoe County. Thank you for the opportunity this afternoon to present AB 489, brought by the Assembly Committee on Judiciary. AB 489 revises the statute of limitations for civil actions related to homicide. With us today is Jerry Feinman, a 30-year prosecutor, Shannon Forsyth with Run to Rescue, and Glendine Grant. To assist with questions, we also have Sean Higgins, Layla Rodriguez, and Kim Ganya with Andrews and Thornton. With the chair's permission, I will turn the presentation over to Jerry Feinman, who is on with us virtually, and I'm going to step back from the table to make room for the remaining presenters here in Carson City. Thank you.
Chair Scheibel and committee members, my name is Jerry Feinman. Gerald, G-E-R-A-L-D, Jerry, J-E-R-R-Y. Last name is F-I-N-E-M-A-N. Over more than 3 decades, I served as a prosecutor where I worked extensively on cases handling domestic violence, homicide cases, human trafficking cases, and other related deaths, including vehicular homicides. Now I work with law enforcement and victim rights groups across the country to provide training on domestic violence, strangulation, victim assistance, and including providing workshops in the Las Vegas area with law enforcement agencies there. I'm here today to express my strong, overwhelming support for AB 489 and to highlight for you how the current legal framework denies many families the justice, particularly in cases involving human trafficking and domestic violence homicides. The current civil statute of limitations for wrongful death claims forces a grieving family into an impossible position, giving them just 2 years to file a wrongful death claim, regardless of whether that death was the result of a murder or by negligence. In reality, those 2 years actually are at best maybe a year or a year and a half, because that statute starts to run from the date of death. And it doesn't account for the time that law enforcement takes to investigate a case, to identify a perpetrator of that violence, and to move forward with that investigation. This is in stark contrast to the statute of limitations under criminal law, because a prosecutor for a homicide can press charges at any time with no limit. So families are now required to file a wrongful death claim so quickly, often before they even know the full scope of the crime. This forces them to choose between rights in civil court versus criminal court, and it really is unfair to them. Working with families of homicide victims for so long, I've witnessed how the intentional act of violence committed by another makes a death, which is already a tragedy, already that much more traumatizing. Many families don't even have the opportunity to consider a civil system as an avenue for justice until years after the death occurs, well past the current statute of limitations. Moreover, very few attorneys actually handle these complex civil cases, so their availability is also limited, making that 2-year deadline harder to meet. For a family to take time to mourn, to participate in the re-traumatizing that occurs in a criminal case, and then to start a civil claim at the same time within 2 years puts an unnecessary and unjust strain on that family. Expecting families to file within that 2-year period is so unrealistic because the criminal case has often just begun. In my experience, a civil investigation, if they start that early, it interferes with our criminal investigation, and it's unwise to pursue both at once. And if they do that and file the civil case, a defense attorney will use that to attack the credibility of the victim's family and portraying them as financially motivated rather than one that is seeking justice. I've personally seen this, and I've seen it sway juries using these tactics, and it damages both the integrity of the criminal case and in turn the strength of the civil case. By way of example, in human trafficking cases, fear and secrecy often prevent the witnesses, many of whom are victims themselves, from coming forward with evidence. Trauma from the homicide may further delay their ability to testify. This delay in gathering is doubly true in civil cases, where the civil case has to wait for the criminal case to conclude. And the civil attorneys don't have the same resources that a prosecutor would have. In fact, civil attorneys are expected to build and verify their cases entirely on their own, independent of the criminal case. Imagine that. They don't have law enforcement officers conducting the investigation. They don't have the same access to forensic services. And if they try to impede the investigation, they do just that. They impede the criminal investigation. So they must independently investigate, locate all the witnesses. Crucial testimony may not be available to them even through the prosecution's cooperation, because it may be necessary for the prosecution to maintain that information. The result is a civil process that fails families, not because their claims lack merit, but because the timeline denies them the full opportunity to develop their claims. AB 489 corrects these injustices by extending the statute of limitation to allow families the necessary time to seek justice. It recognizes the special nature of a homicide case and that it's not resolved overnight, and that a victim's family should not have to choose between the civil or the criminal justice system for an event that is far beyond their control. I've witnessed countless families that have been left devastated, unable to pursue legal recourse due to arbitrary deadlines. I've spoken to parents who've lost children to human trafficking, who were unable to hold their traffickers accountable. And I've worked with families of domestic violence homicide victims forced to watch personally the person who took their loved ones' lives manipulate the justice system and run out the clock. AB 489 changes that and gives them a chance at real justice. The purpose of having a statute of limitations is to provide a deadline for preventing against stale claims and ensuring fairness. The current system counters this goal. And really, could we ever have a time deadline when pursuing justice for a homicide victim would be considered stale? We don't recognize that with criminal cases, because Nevada recognizes that in criminal cases, the statute of limitations for a homicide is unlimited. This bill is not about extending lawsuits indefinitely. It simply is about ensuring that the most serious of our cases are given the time and attention they deserve. It's about giving back to a grieving victim's family and providing them with the opportunity to hold those responsible accountable, both criminally and civilly, without undermining a prosecutor's case. I urge the legislature to pass AB 489 and remove the unnecessary burden on a victim's family. Thank you very much for your time. I would now like to pass the microphone to Shannon Forsythe.
Good afternoon, Senators. Thank you for having me here. My name is Shannon Forsythe, S-H-A-N-N-O-N. Last name Forsythe, F-O-R-S-Y-T-H-E. My husband and I, Bartley Forsythe, are the co-founders of Run to Rescue. an organization dedicated to reaching, rescuing, and restoring victims of sex trafficking here in the United States. For years, we have worked with hundreds of young girls, boys, men, and women who have survived unimaginable horrors. We provide trauma-responsive services, assist in recovery, and we fight for justice. As tragic as human trafficking is, there is no greater devastation than when a victim's life is taken or when they disappear and are never found. We have witnessed firsthand the brutal realities of trafficking: electrocutions, burns, drownings, chokings, and severe beatings, and sometimes death. And yet, what is overlooked is the intersection between human trafficking and domestic violence. In domestic violence cases, the abuse typically comes from a single partner. In trafficking, the same dynamic exists, except the partner also exploits and sells the victim. The similarities between human trafficking and domestic violence are undeniable. Both involve an intimate partner as the abuser. 2, non-compliance leads to consequences: beatings, restraints, threats to loved ones, isolation, and sometimes death. 3, victims, whether trafficked or in domestic violence situations, lose their sense of identity. While trafficking victims may be branded with tattoos claiming ownership, domestic violence survivors bear visible and invisible scars that still mark them as being controlled. Despite the thousands of confirmed human trafficking victims in Nevada, we have no clear number on those who have been murdered. Research published in the American Journal of Epidemiology found that women in street prostitution faced an annual homicide rate of approximately 204 per 100,000, making it one of the most dangerous occupations. If there are 2,000 to 3,000 trafficking victims in Clark County alone, this suggests that 2 to 6 trafficking victims are murdered in Las Vegas each year. However, these murders are often misclassified. When a trafficking victim is found dead, the case may be labeled as a gang violence, domestic violence, or drug-related, obscuring the true scope of the crisis. So why the statue? What's important? I want to share with you a young woman. Her name is Jessie Foster. Jessie was a beautiful young woman. She came from Canada to Nevada in search of a better life. She came with her boyfriend. She became a victim of, instead she became a victim of sex trafficking, and then one day, she vanished without a trace. Her mother, Glendine Grant, was unable to come to the U.S. due to certain restrictions, preventing her from searching for her own daughter. Each time a report surfaced of a young woman resembling Jessie, hope would rise, only to be shattered when it wasn't her. After 19 years of searching, most believe Jessie is no longer alive. So what happens if Jessie's body is found today? What recourse does her family have to seek justice? Jessie will never have a wedding. She will never give Glendine Grant grandchildren. She will never celebrate another birthday. While filing a civil lawsuit cannot bring Jessie back, it can force perpetrators to face accountability. And sometimes that is the only justice a family can get. Nevada current civil statute of limitations does not reflect the complexities of human trafficking cases or domestic violence. Traffickers are skilled at erasing evidence, silencing witnesses, and ensuring their crimes remain buried for years, sometimes decades. Families of murdered trafficking victims deserve more to seek justice. I urge you to support this legislation that extends the statute of limitations for civil lawsuits against those responsible for the deaths of trafficking victims and domestic violence victims. This extension will ensure that when these cases are finally uncovered, when a body is finally found, when a witness comes forward, when justice is within reach, the law does not slam the door on grieving families. And before I close, I want to introduce to you a woman who has incredible bravery and courage for the last 19 years, Jessie Foster's mom, Glendine Grant.
Thank you, Senators. I'm very grateful to be here today. My name is Glendine Grant. Glendenegrant. I got very emotional listening to Shannon. Please forgive me. I'm the mother of missing Jessie Foster. Jessie was taken from Kamloops, BC in the spring of 2005, and after a few stops, landed in Las Vegas on May 13th, 2005, exactly 2 weeks before her 21st birthday. It will be 20 years ago next Tuesday. We thought Jessie was having a wonderful life. She met someone, got engaged, and moved into his beautiful house in North Las Vegas. What was actually happening was she was living a nightmare, and she was too afraid of her captors to say anything to us or to the police. Unknown to us, Jessie was being beaten and forced to work at an escort agency as a prostitute until March 2006. She was also arrested for solicitation for prostitution twice, for 4 charges total in that time. Our private investigator also found hospital records that proved she had been beaten, her jaw was broken, and that was something she never told us. 19 years ago, Jessie went missing. We have not found her, nor have we heard anything regarding her disappearance from anyone who knows the truth in all that time. When a loved one goes missing, or worse, family has many roadblocks that hinder them from getting answers, but it's more than that. We can't work, we have to pay private investigators, offer a reward, travel to different locations, make posters. There's so many things that cost a lot of money, and in our case, emptied our savings account, left us struggling financially for almost 2 decades. My husband and I are both senior citizens now, and we both still work out of necessity. We have no golden years, no travel plans, and nothing other than surviving and ensuring our family is doing okay. Besides financial issues, we also have mental and physical health issues. Jessie's biological dad never got over her disappearance, and at the age of 62, after struggling with heart issues, died of a heart attack in 2020. Here's my daughter, Crystal, Jessie's older sister, also had a very hard time. Well, she couldn't accept that her sister was missing for so long, and her struggles included drug addiction, a battle she lost in 2021. For myself, the stress I have been under has been great. It has not only been from living with the missing child, but also from worrying about my family and our financial situation. On my 66th birthday in 2023, I had a massive heart attack and ended up with emergency triple bypass. Out of all of us, I'm the lucky one. The mother with a missing daughter who is a human trafficking victim is the lucky one. The only thing that has helped me cope through all of this turmoil is the fact that Jessie's story has given voice and inspiration that has helped others escape what might have been the same fate as our poor Jessie. Jessie is everyone's daughter, everyone's sister, everyone's friend, even yours. Through Jessie's case, I started a grassroots organization called MATH, Mothers Against Trafficking Humans, back in April of 2010. And through it, I try to educate women, families, and organizations, and even the police on what to do if you have a missing or murdered loved one. I try to point people in the right direction to get help in the areas they live or where the crime happened or whatever they need just to help find justice and closure. And that's why I'm here today. Ever since my Jessie went missing, I have turned my grief into action, advocating for families, for victims, for change. I've worked with the Nevada Center for Missing Loved Ones and worked on helping victims of missing and murdered Indigenous women, plus so much more. Just a few weeks ago, Jessie's story was an inspiration for an article in the Las Vegas Journal-Review. Her story still continues to inspire and help people through the actions we take. It's been over 19 years since Jessie went missing, but under the current law, we would be prevented from seeking justice because of the statute of limitation laws, and there are more victims and families like ours who are denied justice because of outdated laws. I hope you see us and the struggle that our families go through and the need to update the law to help us secure justice and accountability. Thank you very much for listening to Jessie's story and taking action to honor Jessie. Jessica Edith Louise Foster, my second of 4 daughters, was born May 27, 1984, missing and perhaps dead. since March 29th, 2006. Thank you all.
Yes, good afternoon, Senators. Sean Higgins, S-E-A-N, Higgins, H-I-G-G-I-N-S. I would like to briefly explain the proposed conceptual amendment. This amendment brings clarity and precision to the bill in three important ways. First, subsection 3 of section 1 more clearly defines who may be held liable, limiting it to natural persons and entities that knowingly and directly participated in the killing, whether by providing material assistance, acting under the killer's direction, or operating as the killer's alter ego, consistent with long-standing Nevada law on alter ego liability. For example, in Glendine's daughter's case, we know that her trafficker had multiple businesses which he used to further his trafficking, hide his assets, and commit the suspected killing. This amendment would restrict liability to any entities and only entities that were directly involved and used in the suspected killing. Second, it strengthens the legal framework for bringing a wrongful death claim by aligning it with existing structure used in probate matters and also incorporating a right to a jury trial. Lastly, Section 3 removes ambiguity and eliminates unnecessary language in the retroactivity provision, making the statute more accessible and effective. Thank you.
Thank you, and we're ready for questions.
All right, thank you so much for your presentation, and thank you for being here to share your family's story with us. I will open it up for questions. Members of the committee, we'll start with Senator Wynn.
Thank you, Chair. And if you don't mind, I kind of have some questions maybe for legal as well. Thank you for sharing your story. I do have a couple of questions because I know that this is in this section regarding statute of limitations. And I know at least during my time in the legislature, we have talked about, we've removed statute of limitations for things like sexual assault and for some other things. And there are some other ideas on lookbacks. With this in particular, I know it's in that 2-year, 5-year window. When you're looking at a missing person, I believe, and maybe legal can answer this for me, do you know when a family can declare someone deceased after they've been missing for a certain period of time?
Yep. Thank you, Senator Sean Higgins. I would have to look specifically in Nevada, but most states are 7 years, and maybe somebody knows specifically what Nevada statute is for presumption of death.
It's 3 years in Nevada. My name is Layla Rodriguez with Andrews and Thornton as well.
Is there any particular reason, like at that point, have you found, I don't know if there, it sounds like there's obviously, you have an organization that you've been able to organize and mobilize other victims of this type of crime where you have missing persons, where you may not have discovered the action to be able to, like most of these statute of limitations is not from the date of when the incident happened, but also from the date of discovery, I guess, of when the incident happened. Did you look at, in formulating the language before us, did you ever look at things like the 3-year, statutory requirement that at that time you could determine someone was deceased in order, and then that would trigger like the 2-year deadline at that point? Or do you find that most families do not automatically make that determination to have, their missing loved ones determined deceased after that 3-year time period? Does that make sense? I know I was kind of rambling around a lot in there.
Are you asking what the existing Nevada law is on delayed, if there's any delayed accrual or discovery extensions for statute of limitations and wrongful death?
Yeah, because I'm looking at this. If you can't have a person declared deceased until 3 years have passed at a very minimum in Nevada state law, I can understand why a 2-year statute of limitations would not be helpful. But a 3-year statute of limitations would give you a little bit more leeway. So I guess I'm curious if you have any information, or you can maybe obtain some of that information for the committee on what kind of determinations there are and how long it usually takes family members to decide they're going to make that difficult decision to ask a court to declare that their loved one is deceased?
I don't know that I have an answer to that today. We can certainly look into it. But of course, I want to remind the committee that although we presented for Ms. Grant, missing persons is just a subset of this class of cases. It's just as often or more often where there is a body, or that they do find the body, and the criminal investigation takes many years, as Mr. Feinberg pointed out. So the presumption of death is perhaps relevant to a small subclass of claims, but not the universe. With that, we'll be happy to look into your specific question.
And then, Chair, may I ask a follow-up question about the, and I'm not sure if it was removed in the amendment, but I believe this would also be retroactive. But I know that when I believe, and you know, I'm sure someone will correct me if I'm wrong, but remember that there was only a certain look back when it came to sexual assaults, and it wasn't a completely retroactive thing. Was there any reasoning behind not having, I guess, like a look back as opposed to just opening it up to a blanket retroactivity?
Maybe Ms. Rodriguez can answer that more clearly, but I'm pretty sure the look back sexual abuse statute was unlimited. I think we took most of this language directly from that statute.
Yes, I believe that, in fact, the last time that we submitted an amendment that was directly
I'm sorry,
from that statute.
I'm sorry, we need your name on the record.
Yes, Layla Rodriguez. The last amendment that we made was specific to the sexual abuse retroactivity language. This language today is more in line with an amendment of that we've been working together with the Nevada Resort Lobbyists as well, or association, in order to come to an agreement on our language.
Thank you. I don't have any further questions.
All right, other members, do you have questions for the presenters? Senator Krasner.
Thank you, Chair. Thank you for your presentation. Appreciate it. I'm very sorry for her loss, and thank you for the work you do. My question, I'm looking at the bill, but I'm also looking at two amendments. One from the Nevada Resort Association, I believe one from the drafter of the bill.
Yes.
Yeah, okay, and so I'm trying to reconcile the two amendments, so there's a hope that you guys can come to some middle ground and all work together and pass this. Would a hotel or a resort who, in hindsight, left a door unlocked, and through that door is how this bad person was able to gain access to the building where the person was staying, and then get into their room or somehow apprehend them, and now they could somehow be roped into this and be held retroactively responsible. Is that possible with your amendment and the bill together? Thank you.
Sean Higgins, no, it's not. We have done our very best to expressly limit entity liability and not include vicarious liability. So our language would require unknowing material assistance to the killing, which would not describe a situation of negligence that you described.
Thank you, Mr. Higgins. I meant to address my question to you anyway, so thank you for piping in. So the amendment that you drafted limits liability to a natural person only? Is that correct? Or someone who was, accomplice liability, let's say there's two natural persons, one who is the person that actually kidnapped the victim, and then somebody else who was their accomplice that takes them around and sells them from John to John before they're murdered. I'm just trying to make sure that it's living persons and not a hotel or a establishment. Is that correct?
Our amendment includes natural persons, and it only includes entities for the limited purposes that we have outlined in here, where they knowingly, in other words, they're, as you point out, accomplices to the crime by providing knowing material assistance. They direct the killing directly, or they're otherwise the alter ego. So it's not the case of vicarious liability. It's the independent intentional acts of the entity.
Other questions from
Layla
members?
Rodriguez.
Oh, sorry, go ahead.
Oh, sorry. If I may just expand a little bit with examples. We've found that, especially in trafficking cases, there is a pattern of using entities in order to effectuate that trafficking and, in some cases, those killings. And so a good example is Jessie Foster, Glendine Grant's daughter, where her trafficker actually used multiple different entities, which he owned alone, in order to effectuate that trafficking and, we believe, contribute to the suspected killing. And if we were to limit this to natural persons, it would exclude those entities from being able to be involved, where he was hiding assets and using it in order to direct others to contribute to the suspected killing.
Okay, other questions? Senator Ellison.
Thank you, Madam Chair. I thought the statute of limitations for murder is forever. Is that right? That's my first question. Is it not?
I think the statute of
Sean
limitations.
Higgins.
Go ahead.
Go ahead. I was going to say the statute of limitations for criminal prosecution of murder is forever. This is a civil statute for wrongful death that we're attempting to align the two.
Okay, I thought that was correct. And then how long is the longest cases you can go back on DNA if you did find a body? How long is there any DNA after 3 years or 4 years? Could you answer that?
Hi, Senator Ellison. This is Kimberly DeGonia from Andrews and I can speak to that. I was also a prosecutor for 16 years, and I prosecuted within the cold case unit of Riverside County. And some of our cases, we were able to go back 45 years and solve a murder based on DNA alone or dental records. So to your question, it can go back a substantial amount of time.
Yeah. Thank you, ma'am. Thank you very much.
All right, I'll go next to Vice Chair Flores.
Thank you, Madam Chair, and thank you for sharing, obviously, such a personal and very difficult story in the interest of justice. Two questions, and this is for my knowledge, the first, and then I'll ask my real question after. Do you often see scenarios where a wrongful death suit occurs without an actual criminal charge ever occurring? Do you see those scenarios?
Sean Higgins, yes. We see often is the case for any number of reasons. There's a lack of a criminal prosecution and there's just a civil claim for wrongful death. So that's not uncommon.
Perfect. Thank you for that. And so my next question is, in trying to see other states that potentially had this blanket approach, no statute of limitations, I came across some states where their approach was the statute of limitation runs, and it doesn't start to run until either there is an actual charge or a case is adjudicated. And I wonder, did you consider those possible options? Because I think if we approached it through that lens, the statute of limitations stays open and we don't have a door to it. If there's never a criminal charge, you still have an opportunity to pursue it on your end. But if there's a scenario where years down the road, in the scenarios that you discussed, 10 years down the road, through new DNA evidence or whatever it may be, there's now a formal criminal charge that is brought forth, and then we add some type of statute of limitations there, just to allow for us to hit some type of ceiling and closing out the possibility of a case. And I was just curious to know if you considered that. I'm assuming you may have looked at other states and realized, wait a minute, that doesn't work for us, and here's why. So I was just curious to know.
Thank you, Senator Flores. Sean Higgins. Let me make sure I understand your hypothetical. Your suggestion would be to keep the civil statute of limitations open unless and until there's a criminal prosecution?
Or a charge.
Is that the scenario?
And the only reason I'm saying that is, I think we're always concerned about when we put the only purpose of the existence of a statute of limitations ultimately is because we want to hit some definitive moment where we're no longer going to come back and have this conversation in a courtroom because we want evidence to be fresh. We want an individual who, after maybe they weren't convicted of a particular crime and no one's taken any action, at some point we want there to be some type of a door to close. But I understand that in what you've indicated, in wrongful death suits, you've seen scenarios where no criminal charges are ever filed. But on the other side of it, where there are charges filed and an individual may be found innocent, but you still think you have, and this happens all the time, I've seen it, you still have a very strong civil case because of the rules of evidence. They're very different in civil versus criminal. You know, on the civil side, we can still get this individual because we know we have enough evidence there. I'm just curious to know that in that scenario, if you'd be comfortable in considering a statute of limitations, because it still leaves the door open, right? You can, if there's never been a charge ever filed, then you always have the door open. But once there is a charge, we can consider the possibility of having a statute of limitations from there. And it starts to run at the moment of that. And the only reason I'm saying that is I'm still trying to find some finality to a case. And again, you may say that's impossible, it would never work, or we studied these other states who do that now and we didn't like it for these reasons. I was just curious to know if you've had the opportunity to kind of engage in that dialogue and realize that that wasn't the appropriate approach.
Thank you, Senator Sean Higgins. I'm not aware of a state that has bifurcated it quite that way. I mean, there are some states that tether the statute to the outcome of the criminal prosecution. I'm not aware of a state that has both, where if no charges are brought, it's open forever. And if it is, then it starts. Maybe Ms. Rodriguez has found that in her research. Let us consider that. I think I understand now your point.
Understood. I was just curious.
Layla Rodriguez, I've not, but we'll consider it further and research further.
Thank you.
Thank you. I'll go next to Senator Orenshaw.
Thank you very much, Chair, and thank you to the presenters, and thank you for sharing what you've been through. My question, maybe it's for Mr. Higgins, as to the bill and the amendment. Could you discuss and perhaps give some examples of how liability would be limited against entities versus natural persons? I wonder if you could kind of talk a little bit more about that, or whoever would like to take that question.
Sean Higgins, thank you, Senator. Sure, so I'll take this one. It's often the case where entity liability is reduced by statute, or a lot of states have limited liability for public entities. And those statutes often carve out, if you will, vicarious liability or respondeat superior theories of liability, which is what we're trying to do here. We're trying to capture and limit the entity liability to specific intentional acts of the entity itself. And so we've got three such limitations here: knowing material assistance, directing the killing, or where it's an alter ego. So Ms. Rodriguez gave the example of Ms. Grant's daughter's trafficker who was using these companies as an alter ego. He was the sole proprietor, and he was both hiding assets and using them to facilitate the trafficking. That's a pretty classic alter ego. Directing the killing would also, again, be an intentional act that would be criminal on its own, as would be intentional and knowing providing of material assistance. These are intentional acts. This isn't the case of negligence. And one of your colleagues gave the example of somebody who forgot to lock the door to a hotel room. That would be pure negligence. That's not captured by this. This is criminal conduct, independent criminal conduct of the entity.
Thank you. And may I have a brief follow-up, Chair? There's an unrelated bill this session, and we heard testimony about an apartment complex where there was an employee of the management company who developed an unhealthy fixation with a tenant and had the master key and ended up murdering the tenant. So in a situation like that, the management company was not involved in this, but would it be just the killer that this bill would allow recovery against, and not the apartment complex, the management company, since they weren't involved or directing, what happened?
Thank you, Senator. Without knowing, obviously, the all of the facts of the case, my impression is that would not be the kind of case that would be captured here, because the employee would be acting, outside the scope of their employment, and the entity wouldn't be engaging in the management company, in your example, in intentional acts of its own. But again, I'm not familiar with that specific case.
Thank you. Thank you, Chair.
All right. Any further questions? Senator Nguyen, did you have a follow-up? Okay, go ahead.
I'm sorry. There's just, I'm trying to look at both the amendments, the one that was proposed by the Nevada Resort Association, as well as the one that's here, and kind of trying to consult with legal to see how this would work. Because it looks like, if I'm gathering it, obviously there is one, the intention to get rid of the statute of limitations, similar to like sexual assault cases. And then two, unlike sexual assault cases, those civil actions, it looks like you want to be able to expand this not just to the natural individual or natural person that committed the act, but also to these entities. And I'm just curious on how this takes place with, like we saw with certain churches where they were being sued for, and those were entities that were being sued for like sexual abuse of minors. And so obviously there are lots of those types of lawsuits. Is that in a particularly different statute, or do you not believe that you can already do this under the current law, or just that you would have to do it within 2 years?
Thank you, Senator Sean Higgins. We obviously are involved in the clergy cases. We have quite a bit of those cases around the country. This is even more limited than those scenarios, because those are negligent acts of the church itself. We're really focused on purely criminal conduct of the entity here, and then not pure negligence. So the failure to supervise a clergy member, for example, is an independent act of the entity, but it's based and rooted in negligence. This is rooted in criminal intentional conduct. This would this language that we propose would require the church to actually facilitate the abuse, or direct that the clergy person perform the abuse, which is a totally different scenario. So this language is even more limited, I think, than the scenario you're thinking of.
And so in the current scenario, in the current state of the law, you're only able to go after that individual, like that natural person that committed who was the killer, or, committed the act, within that 2-year time period. And You wouldn't be able to do it after, say, the commencement of a corresponding criminal action. You would have to do it at the same time simultaneously?
Yes. Under existing Nevada law, you would have to bring the wrongful death action irrespective of the timing of the criminal, and maybe Ms. Rodriguez can correct me if I'm wrong there, but and you could bring it against the entity for negligence under existing law. That's not the case of the amendment we're looking at here. We're trying to limit the entity liability to intentional conduct.
If I may, Leila Rodriguez, as it stands, the wrongful death statute does allow for natural persons and entities to be included. This amendment that we're presenting now limits the type of entity and the conduct that the entity would have to do, as Sean Higgins was saying.
Thank you. I don't have any further questions. I can take them offline.
Okay, anybody else? I do have a few questions, and I think, I apologize, this is outside of the area where I practice. I'm still a little bit confused on the language of the bill as well as the amendments. So let me start with the entity liability. And I don't want to be too blunt, but I'm just trying to understand what we're getting at here is that the issue with not being able to sue the entity and only being able to sue the natural person, please correct me if I'm wrong, but the issue is not about who's responsible, it's about being able to recover money from the entity if it's in the name of the entity instead of the name of the person. Am I getting that right?
Sean Higgins, thank you, Senator. That's not quite right. Both are true. It's both the case that the entities are used as vehicles to hide assets in terms of recovery, as you point out, but it's also the case that the entities under our amendments have their own independent liability for their intentional conduct.
So can you
So
give?
it's not just about recovery.
Can you give me an
It's not just about
example?
recovery.
Can you give me an example of the kind of conduct that an entity could undertake where a lawsuit would be successful against the entity but not against the individual who owns or controls the entity?
Sean Higgins, let me try that. Let me rephrase your question because I think you're perhaps missing the point is that both the natural person who controls the entity and the entity itself would both be liable. So, for example, think of like Warren Jeffs colt, right? Both the entity itself has its independent.
I'm sorry.
Conduct.
I didn't hear what you said. Think of
Warren Jeff.
Warren
Think
Jeff.
of a colt. Yes. Think of like a colt that has that is controlled by a single individual, and both the entity, the colt, which is a corporate entity itself, has its own criminal conduct. Both that entity and the individual controlling and running the colt, both of them have liability. So it's not an either or situation. It's a both.
I'm just still struggling to, and you said it yourself, I am missing the point. I'm struggling to understand what kind of fact pattern would lead to a situation where we're unable, taking money out of the equation. Money I understand, but if we're taking money out of the equation, how we would be unable to hold the natural person accountable because we can't hold the entity accountable as well. So what is it that we can prove in court a cult which has an LLC has done, but we can't prove that the human being running the cult is responsible for?
Well, they may not always be the same, right? So the cult, I use an example of a single person that runs the entity, but the entity may be run by other individuals, but the victim has a right to have a jury determine that both the human being that committed the murder as well as the entity in a hypothetical that directed the killing or participated in the killing, which could act through other human beings, that both share responsibility and liability.
So I think where I'm getting confused is that I do understand criminal liability for corporations, for businesses. Generally, that is in the context of some kind of financial crime. I'm still failing to see how an entity, an LLC, a business, a corporation could be responsible for somebody's murder, and we can prove it in court, but can't prove it against actual human beings. I mean, give me the fact pattern.
Right. So a hypothetical would be an entity controlled by Jane Doe running an entity, directs John Doe, who carries out a murder for the benefit of the corporation. Yes, you can hold Jane and John Doe both responsible as human beings. But the entity itself is also a participant, an intentional participant, and shares liability and should be found responsible by a jury for its directing of the killing.
I'm sorry if I'm belaboring the point. I understand that in the context of the corporation is the one that has the money, and you want to get the money from the corporation. And there's nothing wrong with that. I'm a lawyer too. That's what we do. I'm just trying to make sure that we're all being honest, intellectually honest about what the bill does, is it allows the victim or their family to recover money from the corporation or the entity, because I'm still not hearing an example of where it's impossible to hold anybody responsible without including the entity in the action.
I'm not saying it's impossible to hold Jane and John Doe, the human beings, responsible. What I'm saying is justice demands that the entity who participated should also bear responsibility. All three should bear responsibility, and the jury would have to figure out who bears which responsibility and what proportion of responsibility, but the victim is entitled to justice against the corporation as well.
And if I may, Senator Kimberly DeGonia, this scenario could be very likely in the world in which we're speaking of, which is the human trafficking world, where these traffickers are hiding money within their entities and organizations. Those traffickers are oftentimes involved in criminal street conduct, such as gangs. Those gangs are oftentimes rivals, which leads to the person who is hiding the money in the entity quickly dies sooner than they should have because of rival gang members. So the actual person who put out the directive through the entity to commit the murder, he is now dead also. But the money from which he gained and gathered from trafficking the girls is still held within the entity. So the entity could still be sued, even though the director who directed the murder has since died.
So in that context, the gang is the entity.
The gang could be the entity, but also the criminal conduct that the gang engaged in, and kind of like the RICO claims, the things that they've hidden their money in.
So I'm going to throw it to legal real quick. Is it possible to sue a gang?
Goofy button. Thank you, Chair. Well, it's certainly possible for, as you probably know, anyone to sue anyone else for anything. As to liability of that, I mean, there have been some instances where gangs, organizations certainly have been found civilly liable and, had their assets seized. It's relatively rare, but it has happened.
Okay, I appreciate that. That's an excellent example. I think Senator Orenshaw has a related question, so I'm going to throw it over to him for a minute, and then I might have another follow-up. Go ahead, Senator Orenshaw.
Thank you, Chair, for your indulgence. If you weren't able to bring the entity into the suit, but the killer was trying to hide assets or put them in corporations or LLCs, would the plaintiff's family be able to try to pierce that corporate veil and get at those assets even under existing law?
Under existing law, in the absence of this statute, if you had just sued the human being, you would need to pierce the corporate veil under an alter ego theory, as you suggest. The other proposal that you saw would limit it to natural persons and arguably make that impossible.
And a brief follow-up, and I apologize that I also don't practice this area of the law. So then by limiting it to natural persons, you feel that piercing that corporate veil to reach those hidden assets from the killer would be impossible? And I wonder if you could just explain why.
Well, because by spelling it ordinarily in the statutory scheme in Nevada, person includes both natural persons and corporate persons. When you have language that the legislature is specifically limiting it to natural persons, we do not believe an alter ego veil piercing would somehow make the corporation a natural person. You could disregard the corporate personhood in terms of financial separateness, but we don't believe that you could pierce it and make that corporation therefore a natural person and fit within the language of the amendment proposed.
Okay, again, and that's an area I'm not too familiar with, so I appreciate your opinion. Maybe I need to do a little more research on that. Thank you. Thank you, Chair.
Thank you. Okay, I think that did help me a little bit. I'm still wrapping my head around the entity liability, but I will move on because I think I need to do my homework on it and just ask a different question. I completely understand that this bill is not supposed to be limited to cases of missing persons. I absolutely understand that we can have cases where, we do know that someone's deceased and still have some of the issues that we've brought up about the statute of limitations, the timeline for criminal prosecution. I'm just wondering if any thought was given during the process of working this bill. I see that there was already one, if not two, there was already an amendment on the Assembly side, so I'm assuming there have been ongoing negotiations. Have you considered utilizing NRS 156.120, which allows for a missing person to be declared dead, to be utilized as a kind of trigger for a statute of limitations to bring cases in the case of a missing person, like saying, because that statute, I'm looking at it right now, has a petition process, there's a notice process, there's a whole legal process in place to declare a missing person deceased. Have we considered saying, once that process is completed, you still have 2 years, 3 years, 10 years to commence an action for civil liability?
Thank you, Senator. And I meant to circle back.
And I'm sorry,
was brought up.
We do need your name for the record.
Sean Higgins. Sorry, Sean Higgins. Thank you. And I meant to elaborate earlier in response to Senator Nguyen's question. The problem with the presumption of death and the process by which you can have somebody declared dead in the case of a missing person is that it only solves half the problem, which is, are they dead? It doesn't answer the question in some cases, maybe perhaps not Mrs. Grant's case, but in other missing persons' case of who's the murderer. Just because you can have them declared dead doesn't mean you necessarily know who the murderer is. That's the problem with the missing person's presumption of death, is it only answers one of the factual questions on that timeline and perhaps not the other half.
I'm not understanding your answer, because doesn't the whole proposed policy depend on having a person that you're planning to sue? I mean, that's what the court's supposed to be determining, is whether or not you're correct about who committed the murder.
Right. So in your hypothetical, Sean Higgins, thank you. In your hypothetical, you could get a presumption of death, but if the statute ran from the presumption of death, but you didn't know who the killer was.
Oh, I see what you're saying. So they might
be able to bring this action.
They might be declared dead after 3 years, but you don't find out who the killer is until 10 years later. Is that what you're saying?
Yes. Yes.
Okay. And there's not another statute that allows for the statute of limitations to trigger upon discovery? That might be a question for legal.
If I may, Leila Rodriguez, there isn't an enumerated discovery rule in statutory law. However, there is a discovery rule. It gives 2 years. However, those 2 years are still limiting to family members who are discovering the tragedy of this information, as we heard earlier from multiple different witnesses who came and spoke. Furthermore, that discovery rule depends on a showing that you reasonably should have known or shouldn't have known of the material facts of that death. So there's also this reasonability analysis that's further limiting upon a family. And that could get even more complicated if we have a declaration of somebody being deceased through a missing persons analysis. So as it stands right now, that 2-year discovery rule is insufficient.
Okay, I think that answers my question. Based on that, I don't see anybody else popping up with additional questions. I do appreciate everybody taking the time to be here, especially Ms. Grant being here and sharing your story with us. I know it can't be easy, so thank you for taking the time out of your day to be here. And to all of you for answering our questions. With that completed, we will now move into testimony. We will start with testimony in support of AB 489. Anybody wishing to give support testimony in person is invited to the front of the room here in Carson City and Las Vegas now. I don't see anybody coming forward to give support testimony in person, so we will go to the phones, please, for support on AB 489.
If you would like to testify in support of AB 489, please press star 9 now to take your place in the queue. Good afternoon, Chair and members of the committee. My name is Riley Svensson, R-Y-L-E-Y, S-V-E-N-D-S-E-N, and I am the Policy Specialist with the Nevada Coalition to End Domestic and Sexual Violence. NCE-DSB supports AB 489, which allows grieving family members to pursue civil litigation in the aftermath of wrongful and violent death. The current standard of seeking litigation within 2 years is not victim-centered, nor does it take into account the complexities that go into conducting and finalizing a criminal investigation. Bringing forward a civil claim while a homicide investigation is underway can jeopardize the investigation, and often the families are waiting for the investigation to conclude to receive final answers and closure. In 2024, 49 individuals lost their lives due to domestic violence homicides in Nevada. I think it's safe to assume that many of these criminal cases and investigations are still active with criminal procedures pending. The family of these individuals deserve to pursue civil litigation if they choose to and should not be held to stringent time constraints. This legislation is a common sense, victim-centered bill, and we urge its passage. Thank you. Chair, there are no further callers wishing to testify in support at this time.
All right, then we will go to testimony in opposition to AB 489. Anybody wishing to testify in opposition is invited forward here in Carson City or Las Vegas now. We will start in Carson City with in-person testimony.
Thank you, Chair Scheibel and committee members. Misty Grimmer, G-R-I-M-M-E-R, representing the Nevada Resort Association. The Resort Association has been in conversations with the proponents of the bill since the hearing on the Assembly side, but as you can tell, as of yet, we have not reached agreement on amendment language. We believe that the amendment language that we submitted would still hold the actual natural person responsible for the killing of the victim accountable in a civil proceeding and remove the statute of limitations in those circumstances on the actual person. The amendment that was presented during the bill hearing on the Assembly side and the amendment that the proponents have presented to you today expands the scope of the bill to include entities that are not directly responsible for the killing. This seems to go far beyond the goal of families seeking justice against the killer of their loved ones. Eliminating the statute of limitations is an extraordinary change in law. Making a law retroactive is very uncommon and a much bigger change. Between those changes and the reluctance by the sponsors to limit the bill to natural persons who committed the killing, we are, as I believe the committee is, questioning who this bill is trying to target. There's already no statute of limitations for these suits that relate to sexual assault or rape because presumably the victim is able to participate in the proceedings even if it's many years later. For cases of wrongful death that bring in entities that could have accountability, since those cases do not have to wait for there to be a body or any criminal finding, it's appropriate that the law remain as is, requiring those cases to be filed within a prescribed period of time. Many of the questions that the committee have asked are the same questions that we've posed to the sponsors and the proponents of the bill of who are we really trying to target? We continue to have conversations with them and hopefully we can narrow that scope down so that it really is only held to the people accountable for the killing. Finally, as more of a drafty concern, we're perplexed by the language in Section 3 being represented in the bill as simple transitory language when Section 3 is actually the very crux of the bill and is a significant statutory change, but that's more of kind of a drafting question for LCB than it is a policy question. Thank you.
Good afternoon, Chair Scheibel and members of the committee. My name is Jeff Rogan, Jeffrogan, and I represent Clark County. The county respects the intent of the sponsor and the proponents of this bill to bring accountability to the families of victims of an unlawful homicide. We and many other local jurisdictions have been monitoring this bill and appreciate the removal of the term homicide from the statute because that term includes both criminal and non-criminal killings. The changes made today or proposed today focus on those intentional killings only. However, the county and other local jurisdictions still have concerns that regarding the amendment that was shared with us yesterday. The amendment as drafted could inadvertently affect provisions in NRS Chapter 41 concerning exceptions to our sovereign immunity and could also unintentionally extend the statute of limitations for Section 1983 actions. We've spoken to the proponents just today. They have made clear that that's not their intent, and we're working collaboratively with them to address these concerns. Thank you.
Good afternoon, Chair, members of the committee. Paul Maratkin with the Vegas Chamber. In regards to AB 489, the Chamber does want to thank the proponents for meeting with the Chamber and discussing this bill since its passage in the first House. And of course, the Chamber offers its condolences to the families. The Chamber does have concerns about the bill as redrafted in print 1. And of course, the Chamber has no issue about the bill, the premise trying to go after the actual killer of the bill. I'm sorry, the actual killer as proposed in the language. However, we do have concerns about the language being so broad. It does create concern to the business community as unintended consequences regarding how business entities will be included, and there will be statute of limitations, especially since the amended version does not say intentional or criminal intent by the business entity. We are concerned about that. The Chamber is in support of the Nevada Resort Association amendment that's been proposed. If that was adopted, the Chamber would move to neutral. Thank you, Chair, members of the committee today.
Good afternoon, Madam Chair, members of the committee. Brian Wachter, WACHTER, Senior Vice President of the Retail Association of Nevada. We too are in favor of the amendment proposed by the Nevada Resort Association. We think if it doesn't happen, that eliminating the timelines on civil liability, no matter how well-intentioned, fundamentally alters the expectations and risk landscape for businesses large and small. Retailers could be drawn into lawsuits decades after an incident when records have long since disappeared and key personnel are no longer available, making a fair defense nearly impossible. This is not only going to undermine our legal predictability, it introduces new and potentially significant financial liabilities that affect insurance costs, employee training requirements, and operational practices. The result is both a chilling effect on investment and growth and an increase in prices for Nevadans, particularly for small retailers who operate on thin margins and lack the legal infrastructure to absorb these long-term risks. We urge the committee to support more compromise on this issue, and thank you for your
All right, I don't see anybody else coming forward to give testimony in opposition to AB 489 in person, so we will now go to the phones for opposition testimony on AB 489.
If you would like to testify in opposition to AB 489, please press star 9 now to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
Okay, then we will go to testimony in neutral on AB 489. Anybody wishing to give neutral testimony is invited forward to do so now. I don't see anybody coming forward to give neutral testimony, so we'll go to the phones, please. Neutral testimony on AB 489.
If you would like to testify in neutral for AB 489, please press star 9 now to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of testimony. Unless the presenters have any closing remarks, please come on down to give those now.
Sean Higgins for, oh, sorry, go ahead.
Go ahead, Sean.
Nope, you were probably going to say what I was going to say. Go ahead.
I was just going to, Martin Fitzgerald for the record, I was just going to share a statement from Exquisite, their closing line and their testimony and support online. Death from homicide is permanent. Justice for victims should not be short-lived. And with that, we urge the committee to continue to work with us on this bill and find a place to land on the.
Thank you so much. All right, I will now close the hearing on AB 489. I will open up the hearing on AB 88 and welcome our presenters forward.
Good afternoon, Chair Scheibel and members of the committee. My name is Angela Knott, A-N-G-E-L-A-K-N-O-T-T, and I represent the Washoe County Public Defender's Office. With me today to present AB 88 is Stephanie Cook, S-T-E-P-H-A-N-I-E-C-O-O-K, and Catherine Marr, K-A-T-H-E-R-I-N-E, M-A-H-E-R, and they are both with the Washoe County Public Defender's Office as well. As a brief introduction, Stephanie Cook is the Chief Youth Defender at the Washoe County Public Defender's Office. Ms. Cook has been with the office since August 2021 and has led the Youth Division since July 2022. She brings over 15 years of experience representing both youth and adults across Nevada's criminal, dependency, and delinquency systems. In her current role, she oversees a team of 3 attorneys, 2 legal assistants, and an investigator mitigation specialist. She also manages adult parole revocation hearing coverage before the Board of Parole Commissioners, all while maintaining a full caseload representing youth involved in the legal system. Ms. Cook previously served in 2 sessions as Deputy Legislative Counsel, including as counsel to the Legislative Committee on Child Welfare and Juvenile Justice during the 2012 interim. Also here to present is Catherine Marr, who has served with the Public Defender's Office for 7 years, including 5 years in the role of Deputy Youth Defender, where she has dedicated her practice to advocating for justice-involved youth. Ms. Marr originally presented AB 88 to the Assembly Judiciary Committee and will help address the amendments made to AB 88 today. Now, the goal of AB 88 and the amendment is to let everyone involved in the juvenile's criminal case to share their views on the right level of supervision and consequences for a child, but leave that final decision to the judge, not the prosecutor. The judge should be able to send a case back for informal handling no matter what charges the child admitted to or what the DA recommends. This does not mean skipping the dispositional report. We are not going to skip victim input or evaluations like a risk assessment or mental health screening. All that information would still be gathered and considered. Oftentimes, these reports are helpful and will show that the child is low risk. Our amendment clarifies the intent to ensure all parties are heard, but that the judge has the discretion to place the child in informal supervision. But because these ladies are way more qualified than I am, I will now turn it over to Ms. Cook and Ms. Marr to explain AB 88 in more depth.
Thank you, Chair and members of the committee. Stephanie Cook for the record. As Ms. Knott indicated, the overall goal of AB 88 is to allow the court, after hearing all relevant information, whether that be victim statements, victim impact, restitution amounts, mitigation provided by the defense, any mental health or substance abuse evaluations that may have been previously obtained for the youth, as well as the youth level of services inventory known as the YLS, which is a risk and needs assessment that looks at a wide array of domains for the child to determine that child's specific needs and risks and strengths and protective factors. So the judge would have all of that information before they make that ultimate decision as to what is the appropriate level of supervision for the child in their specific case. The way that the juvenile legal system currently operates is that the overarching goal is not punishment like we might see in the adult criminal system. However, the goal is to provide rehabilitation and services and guidance to the youth to help them make better decisions in the future. And so from our standpoint, what AB 88 would do is really give the judge the ability to do that. To that end, juvenile probation departments have the ability to provide varying levels of supervision depending on the risk and needs of the youth, as well as a continuum of services and support for the child and the family where they may need it. And so what we would like to see is that regardless of the level of charge, whether it's a misdemeanor, a gross misdemeanor, or a felony, the judge would be able to take into consideration all relevant information to determine what level of supervision, specifically the ability to refer that matter back to probation to be handled at the informal supervision level. Right now, under current law, in order for a gross misdemeanor charge or a felony level charge to be referred back for informal supervision, both the district attorney and juvenile probation must agree to that arrangement. So even if the judge hears compelling evidence or information during a hearing, the judge does not have the ability to refer on its own discretion that matter back for informal handling.
Catherine Marr for the record. I'm going to jump off of what Ms. Cook has provided and just give a little additional background. This bill has, or the intent behind this bill has come on a fairly long journey over the past 5 years. This issue was first brought to our attention when we were dealing with vape cases where youth were charged with a felony possession of controlled substance. For many of these youth, it was their first offense. They may not even have used the vape pen. They may have just been in possession of it. Not a significant history, low risk. everything that we would like to see for a youth who's not further integrated into the formal system with the filing of a petition and being in the courtroom and being subject to formal probation, supervision, drug testing, all of those things. Unfortunately, due to the policy at the time, those youth were entering the system with felony charges, and we were unable to get them back into the informal setting due to the way that the law is currently written. So that's where the conversation started. As Ms. Cook indicated, the goal of this bill is really just to open up that discretion to the court, allow the judge, when appropriate, to send these youth to the less restrictive, I guess, setting of what's offered through the juvenile system. To give some explanation of what informal handling is, you get assigned a case manager, you complete community service, you may complete some of the classes that are offered, you could pursue evaluations and counseling, you could pay restitution. So there's still quite a lot that can be done in that informal setting that does not require a formal probation officer and some of the Fourth Amendment waivers that come from formal probation. Really what this bill does is allow the judge to assess the youth and send them back there to that setting. Our initial iteration of the bill, it implicated some of probation's discretion at the lower level. This new change, the most recent conceptual, or the first conceptual amendment, removed the probation officer's discretion to address the concerns that were stated by Clark County District Attorney's Office at that time. And then this newest conceptual amendment, again, we are attempting to address some of the concerns brought to us by the District Attorney's Office. There was concern that the prior drafting would result in perhaps a sua sponte dismissal or the court not being able to review the important information to properly assess the child. Our goal in this latest amendment is to really fine-tune, simplify, that this is just an effort to give the court the discretion to send the appropriate youth back to that informal arena. And with that, I think we're open to any questions.
And thank you all for the presentation. We'll open it for questions. We'll start off with Senator Krasner.
Thank you, Vice Chair. Thank you for your presentation, and thank you for the work that you both do. So I did have someone from the District Attorney's Office approach me about the bill. They had concerns, but it was probably a month ago. Are all the parties, including District Attorneys Association and public defenders, in agreement now with this new amendment?
Catherine Marr, for the record, we did provide this most recent amendment. I would not say that that's the case. We don't know at this time how the District Attorney's Office feels about this latest amendment. It was our effort to get ahead of some of the issues that they saw.
Excuse me, members, additional questions? Seeing none, thank you again for the presentation. I'd like to invite you to sit back. And I'd like to invite anybody wishing to testify in support of, Assembly Bill 88 to please come forward, Carson City or Las Vegas. Good afternoon, welcome.
Good afternoon, Vice Chair Flores and members of the Senate Judiciary Committee. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. We support this bill. It allows judges to see all the options on the table, hear from both sides, and ultimately the judge can make the best decision that they feel it's for the youth. Thank you.
And thank you. Anybody else wishing to come forward in support? Seeing none, we'll go to the phone lines. Anybody wishing to testify over the phone in support of Assembly Bill 88?
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
Thank you. At this time, I'd like to invite anybody wishing to testify in opposition to Assembly Bill 88, if you could please come forward. Carson City or Las Vegas. I do see somebody joining us in Las Vegas. Good afternoon and welcome from Las Vegas.
Hi, good afternoon, Vice Chair Flores and members of the Senate Judiciary. I'm Bridget Duffy, Assistant District Attorney in Clark County, Nevada, over the Juvenile Division. It's BRIGIDDUFFY. I know I only have a few minutes, but I want to talk about statutory construction on this bill. I heard the testimony. I heard the public defenders say that it is the intention that it would be after a plea, it would be at disposition, it would be after the victim is heard. But that is not what this bill will do. NRS Chapter 62 is broken down into several different sections. Section 62C is titled Procedure Before Adjudication. It does not require a plea. It does not require victim statements. It does not require risk assessments for the court to consider. Chapter 62E is Procedure of Dispositions. So by placing their bill, their language into Chapter 62C, what it does is it cuts the state out, the district attorney, the victim of the voice of the victim and the community out of the process. It cuts us out for cases involving sexual assault. It cuts us out for murder or attempt murders, because this would include all felonies and gross misdemeanors. Currently, current law, misdemeanors, if the DA's office files them, a misdemeanor before the child enters a plea, the court can dismiss the petition and send it back for informal probation. What this bill does is adds gross misdemeanors and felonies to any time we file a petition, the court can dismiss it and send it back for informal probation. Again, sex assaults, homicides. This is all about vape pens, which my understanding is that in Washoe, they were filing vape pens as felonies. They've now fixed that procedure. In Clark, we do not file vape pens as felonies unless they are selling them. And so most of our kids with vape pens are getting dispositions of diversionary services for first-time offenses. This is taking it and the community out of the conversation, and it eliminates an important check and balance. And I even question if it's constitutional because of the separation of powers issue of if the state files a petition, can the judge, without hearing evidence or getting an admission from anybody, be able to just sua sponte dismiss a case? But that is what this statute would do. And I urge you to look at the statutory construction of where they have put this language into Chapter 62C. Thank you very much.
And thank you for joining us. I think we have a couple of questions for you. Senator Wynn, please.
Thank you, Ms. Duffy. I have a question about this. I mean, I understand that the placement of this language in this particular section of the NRS you think is inappropriate. If this was to be moved to another section, would you have any issues with that? Because when you look at the plain language of this amendment, I'm not sure if you're looking at the conceptual amendment as prepared by Washoe County Public Defender, but
I'm sorry, I don't have a conceptual amendment. I went on to Nellis this morning and there was nothing in there. So I'm sorry, I do not have anything in front of me except for the reprint number 1.
I think that's where there's some confusion. The bill that was presented to us was with the conceptual amendment. And the conceptual amendment, while it is in 62C.230, it specifically says that if the district attorney files a petition with the juvenile court may, A, after the child admits to the unlawful acts in the petition, dismiss the petition without prejudice and refer the child to the probation officer for informal supervision, 1, upon stipulation of the parties, or 2, if the juvenile court finds informal supervision to be appropriate after a hearing on the matter. And then it goes into the rest of the statute. So the plain language of what it sounds like you are not aware of, it appears to also include the district attorney. It also requires the child to make admissions to those unlawful acts, and even requires a full judicial hearing on the matter as well. So I know that you don't have it in front of you today, obviously. Is it possible for you to take a look at that? Because it seems to clear up some of the concerns that you had in your opposition testimony. And I know that you're kind of at a disadvantage right now because you don't have that.
Thanks to my friend Dan Musgrove, Bridget Duffy for the record, and thank you, Senator Wynn. He just emailed it to me or texted it to me, so it just popped up. But I will say I still have a statutory construction problem. That is a disposition hearing. Once a child admits, you go to a disposition, and at that time, the court already has the ability to dismiss the allegations after hearing from everybody. So even if we go to a full trial, and I mean, the court can still dismiss a petition. It's still not in the proper section of our statute. I don't know why they want to put it in 62C when a child can enter an admission and go to disposition in 62E, and this court can still dismiss and refer to any type of probation. They could dismiss and close. They could dismiss, close, and seal. They could dismiss, or they could find it to be true and put them on 6 months probation. They could do all of those things. So I don't know the purpose of putting it in a section called pre-adjudication and all the steps that would come at a disposition hearing.
Thank you for that. I don't know if it's possible, Vice Chair, but maybe if there's an opportunity for closing, if we might be able to ask some additional questions based on that. I understand the opposition's concerns, but I mean, that's what we do here in the legislature, is determine where things are going to be statutorily. So if we need to change that statutory construction, I'm just curious on why this was looked at to be housed at here rather than, as Ms. Duffy has indicated, and that's probably a question for the bill sponsor. So thank you for answering that question.
But Bridget Duffy for the record, and looking at this conceptual amendment, I am not seeing anything that says there's to be a full hearing with the victims to be heard. It says stipulation of the party, or basically if the court finds that it's appropriate. So basically if the DA doesn't agree, the court can still overrule us without hearing any from the victim, or so it's still.
Well, I would respectfully disagree with you. I mean, it says you don't have it in statute anywhere else where it's like a full victim hearing on the, I mean, it says a hearing on the matter. I don't know what that would mean otherwise.
Our victims under our Nevada state constitution have a right to notice and be heard under Marcy's law. So Bridget Duffy for the record, I think that we're missing them out.
I think you're assuming that I'm sorry to interrupt you, but I think you're assuming that because you would not notify and the court would not notify the victim prior to this hearing. And I am assuming that you would notify them and the court would abide by the constitutional protections of Marcy's law, as they do in all other hearings that we have in our court process.
Bridget Duffy for the record. This is a pre-adjudication section of our statute and pre-disposition. So disposition, for those who don't know, is sentencing. So that is where we have dispositions and we sentence cases. So that's why I'm saying it's not in the proper section, because after a child admits in juvenile court, we send for an assessment, which we heard the public defender say they would do all of those same things. So then they have to go for that assessment. So then we have a disposition hearing where the court would determine under 62E whether or not to dismiss the case and refer back for informal probation, or dismiss and close the case and the kid's not on probation at all.
I mean,
This-
we could go back
this
and forth. I think
confuses
we
our
just
system.
fundamentally disagree on the reading of this amendment. One is the stipulation of the parties. So I'm assuming that means that you as the district attorney, if you did not agree to this and you had not had contact and the victims were not notified and didn't have like any information about the disposition of this pre-adjudication type of like proceeding, you would just say no. And then secondarily, it would have to go to a juvenile court to have a full hearing on the matter, or a hearing on the matter. And at that point, the victim would be able to be notified to be present of that full hearing on that matter. I mean, we do have, our courts are in compliance with Marcy's Law all the time on these pre-diversion like programs as well. So I don't understand how this would be any different, but you don't have to respond to that. I can talk to you about this offline. Sorry to take
Thank
this
you very
committee's
much
time.
for your time.
Members, any additional questions? Seeing none, thank you again for joining us. Anyone else wishing to come forward in opposition to Assembly Bill 88, Carson City or Las Vegas? Seeing none, we'll go to the phone lines. Anybody wishing to join us over the phone in opposition to Assembly Bill 88?
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
Thank you. Last, we'll move to those wishing to testify in the neutral position to Assembly Bill 88. Anybody in Carson City or Las Vegas? Seeing none, we'll go to the phone lines again. Neutral for Assembly Bill 88.
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
Thank you. Any closing remarks?
Angela Knott for the record. I just wanted to clarify real briefly the two different amendments that have come out of the original proposed AB 88. So based on opposition from Ms. Duffy in the Assembly, we created a conceptual amendment that passed through the Assembly. And then based on further opposition and comments from Ms. Duffy, we created this new conceptual amendment. And I did reach out to Ms. Duffy on May 2nd. I sent her an email, CC'd our team, and wanted to email her the conceptual amendment to get her additional comments on it. I did not receive a response. Now I'm thinking maybe she just didn't receive the email, but I did just confirm that I sent it. Was hoping for any additional comments from her. But this conceptual amendment is based on those comments from the last Assembly hearing that we had. But to further clarify some of those questions, Ms. Marr is going to take over.
Thank you, Catherine Marr, for the record. The primary reason why AB 88, this language change, is in NRS 62C is because that's where this bill already was. So NRS 62C 200 and NRS 62C 230 combined already created this outcome. The only thing we're changing is that the district attorney has to sign off on gross misdemeanor and felony cases. So this is an outcome that was designed in NRS 62C, in part because it's not a final disposition. The petition, as stated, is specifically dismissed without prejudice, meaning the case can come back. And there's further protections in Title V that outline what informal handling is. One of those parameters is that youth needs to be able to complete their sanctions within 180 days. So again, if a youth is not able to complete their sanctions, informal handling isn't a good fit. There's actually a mechanism for this case to come back to life. So that's why it's appropriate in this section. It's giving the youth an opportunity to have almost a diversion opportunity to complete things at an informal level. They could theoretically then come back to court and have a full adjudication. Our goal in this language change is to address the state's concerns and have that hearing where everyone can be heard. We could get the YLS, they could notice the victim, and the informal handling as ordered by the court is done with the information that the court needs to make an educated and appropriate decision. Yes, the vape cases are what first triggered this conversation, but really anywhere you see that tension between misdemeanor, gross misdemeanor, or felony, this applies. Another example would be, if a youth is charged with a battery, that's a misdemeanor. As the law is now, the judge can refer the case back for informal handling. If instead they were charged with a gross misdemeanor challenge to fight, the judge doesn't have that discretion, even though technically the elements of that charge may be even less egregious than an actual battery. Another example would be destruction of property. A misdemeanor is based on value. Gross misdemeanor felony is based on a higher value. There we're having a youth's consequences determined by the value of the item, not necessarily the different actions of the youth or the different characteristics of the youth. So I think there's a number of examples where the judge's discretion is appropriate, and that's what we're asking with this bill. I have nothing further, thank you.
Thank you, and we do have one additional question for you. Senator Nguyen, please.
Thank you. I appreciate that clarification, and I think a lot of the confusion probably comes from the fact that it sounds like Ms. Dusby, there was some sort of I'm glad to hear that you guys have been communicating and that making some of these changes to try to address the concerns. In the opposition, it was mentioned that you could have these serious cases like felonies and gross misdemeanors that wouldn't be able to be adjudicated this way. So it's good to hear some of those examples. When we're talking about more serious, I guess I know they're all gross misdemeanors and they're all like felonies, but it sounds like a felony case was a vaping case until that was a change in policy, not necessarily in law, but that was at the discretion of that office to make that decision to not charge those kids with felonies any longer. But if you had like a more serious charge, like, I don't know, a sexual assault or an attempted murder or something that was more serious that maybe didn't rise to a level of being certified up as an adult, but was something that was, I guess, a more serious, more violent, I guess, type of charge. You said that it would be included in here, but is the intent of having that new Section 1 and new Section 2 to protect or allow like the district attorney to either say, no, we don't believe this is like a challenge to fight versus a battery kind of like situation, and that we don't want to agree to this? And then furthermore, is that second section, is that intended to make sure that there's a full hearing on the matter where a judge could say, yeah, this doesn't rise to the level of this informal probation? Is that why those were included, to address those concerns?
Absolutely. Yes, Catherine Moore, for the record, that was the reason for the addition, to put some safeguards. Our stance was that this wasn't necessarily needed, this changed language, but these are protections put into place to make sure that the district attorney's concerns are addressed. And so yes, short answer, yes.
Members, any additional questions for closing remarks? Seeing none, thank you again for the presentation and joining us today. With that, we'll go ahead and close out the hearing on Assembly Bill 88. And the only other item we have on the agenda for today is public comment. Anybody wishing to join us for public comment, Carson City or Las Vegas? Seeing none, we'll go to the phone lines. Anybody wishing to join us for public comment over the phone?
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
All right, sounds good. Members, just as a lay of the land for tomorrow, we plan to meet upon the adjournment of Commerce and Labor. So, and we have no idea what time the adjournment of Commerce and Labor is, but please monitor the Commerce and Labor Committee. We will be meeting upon adjournment of Commerce and Labor for tomorrow. This meeting's adjourned.